If you set up a trust but you don't put the assets inside that trust correctly, you're not going to have asset protection from your creditors and your lawsuits, and your assets will not avoid the probate process before they get distributed out to your family. In this video, we're going to talk about how to properly fund a trust and how to put real estate, financial accounts, and your LLCs inside of a trust. So even if you set up a trust so that your properties have asset protection and avoid the probate process, but you don't transfer the ownership of that property out of your name into the name of the trust, and you pass away with that property in your personal name, even if you have a trust, it will have to go through the probate process before it can be distributed out to your family. The other problem is if you're setting up a trust for asset protection and you get sued or you have creditors coming after your estate, they can force you or your beneficiaries to sell that property off to satisfy those liabilities before you can distribute them out to your beneficiaries. And so you can use either a quitclaim deed or a warranty deed to transfer the property out of your name into the name of a trust. Typically, you would use a warranty deed to maintain your title insurance and not have any hiccups when you go to sell that property. And so with that document, what you're going to do is put your name, the name of the trust, a legal description of the property, and sign it in front of a notary and witnesses per your local state laws. Then you would take that document and file it at your local county clerk's office in the county where that property is located. They will process that document and transfer ownership out of your name into the name of the trust. And at that point, the property will be in the trust and you will be done. You need to make sure you're doing two things when you put a property inside of a trust. One, you are updating your lender and letting them know that you have transferred the property into a revocable trust. If you're using an irrevocable trust, it will trigger the due on sale clause, and you'll have one of three options. You can get permission from your lender, refinance that property into the name of the trust, or pay the property off completely. In terms of your insurance, with a revocable trust, you need to add the trust as the additional insured on your insurance policy, and you will be the named insured. With an irrevocable trust, you will have a brand new policy with the trust being the named insured and the trustee being the person that would control that insurance policy. If you do not update your insurance policy and you file a claim on the property inside of a trust, they have the right to not pay out that claim because you have assigned ownership into the trust, which is a breach of the agreement that you have with that insurance provider. The next thing we're going to talk about is our financial accounts like checking, savings, investment accounts, etc. If you do not transfer these into your trust or name your trust as a designated beneficiary on these accounts, then when you pass away, these accounts will have to go through the probate process before they can be distributed out to your family. So the three main options that we have here is retitling those accounts into the name of the trust. If those institutions will not allow you to retitle those accounts, you would transfer those accounts into the trust. And if you don't want to do that, then you can name the trust as a designated beneficiary on those accounts. That way, when you pass away, those accounts will automatically dump to your revocable trust and you can control the distribution out of there. Now, some tips here. If you are doing it for asset protection, you would need to either retitle those accounts into the trust or transfer the money into the trust and set up those accounts in there. If you're only trying to avoid the probate process, you can do one of the first two options, or you could just set the trust as a designated beneficiary, and all three situations would avoid the probate process. Now, in terms of your LLC, if you pass away with the LLC membership in your personal name, it will have to go through the probate process before it can be distributed out to your family, and they take over the ownership of it. Also, if you hold the LLC membership in your personal name and you have lawsuits or creditors coming after you as an individual, they are coming after the assets in your personal name, which would be the LLC membership. Now, generally what they're going to be able to do is do a charging order on your LLC, which means they can garnish your distributions. And if the courts decide you're not going to pay off those creditors in a meaningful amount of time, they can allow them to foreclose on your LLC membership, take it over, take your voting rights over. They can remove you as the manager and liquidate the assets inside that LLC. So what we would do to transfer the LLC membership into the trust is draft an assignment of membership interest for that LLC that would transfer the membership interest out of your name and into the name of the trust. You would need to sign it in front of a notary and witnesses per your local state laws, and then you need to keep copies with your trust and your LLC records. And then you need to update your LLC's owner ledger and your membership records to show that the trust actually owns that LLC membership interest. You also need to make sure that you are updating your operating agreement so the trust can actually own the LLC membership interest. Because some LLCs have rules and restrictions inside of their operating agreement that disallow a trust to own the LLC membership interest. And if you try to transfer the membership interest into the trust, then it can be invalid or challenged later. So your operating agreement should have a clause in there talking about the transfer of the membership interest. And so if your operating agreement does restrict it or it doesn't mention it at all, you want to add a clause in there that states that the membership interest can be transferred into a trust without permission and without consent. And then we just want to go through and double check that we have actually transferred everything into the trust, or we have assigned a designated beneficiary as the trust for all of our accounts and our properties. So we want to make sure that the titles for the properties have the trust listed as the owner of that property. For the LLC membership interest, we want to make sure that the membership interest is actually in the name of the trust. And then for our financial accounts, we either have retitled those accounts into the name of the trust, we have transferred the money into the trust, or we have set the trust as a designated beneficiary. And now we have set everything up, it's properly funded, and if you want help setting any of this up, click link in the bio, fill out the form, and schedule a time to talk to some of our team.